let's talk about the deposition planning template. So this is our template when we know depositions are coming up or we're going to be taking or defending depositions. And one thing that we always want to do is make sure the lawyer has a current vacation letter on file, so you don't get notice of depositions that you can't attend. So that's important to do. Take a deposition. So we have two categories under this template. One is when you're the one taking the deposition, and one is when you're defending the deposition, because your steps will be different, obviously. So under the category of take a deposition, one thing you'll do is ask opposing counsel for available dates. Otherwise, you're just going to have to renotice all of them. So you might as well get coordinated in that way. Then you're going to have your notice drafted, and this allows you to assign that to someone if someone else will be drafting it in your office, and to have a deadline by which they should have it to you. You'll ask, you'll include in that notice whether or not it's going to be videotaped, and you have to give 15 days notice if you intend to take it by videotape. And you have to include that in your notice that you're taking it by videotape. Or you could get there, you could have your videographer there, and they could say, you didn't put it in your notice, no video. I like to take video because 80% or some very large portion of communication is nonverbal. Well, when you hear that large of a portion is nonverbal, it seems like the videotape would be more important than the transcript. So you definitely, if you can afford it, and it is a little bit more expensive, it's nice if you can take a video deposition. And if you think about it, if you read a transcript and you just saw on the paper no, that's one thing. If you're watching them in a video deposition and they hesitated and they looked around, they kept looking at their lawyer, then they screamed no, that would be very different, wouldn't it? Your reaction to that would be very different than just reading the word no on a piece of paper. So it is powerful. You also need to decide if you're going to include a ducus tecum. So the ducus tecum is a request for information for documents, and if it's a party, and you'll notice when we cursor over our little I's, we get more information. If it's for a party, you cannot circumvent the 30-day rule. That a party would have 30 days normally to answer discovery. They still get it. You can't circumvent that by just taking their deposition really quick. Wouldn't that be nice, though? So you have to give them 30 days notice. If you'd rather do discovery first and then take their deposition, you might consider that in your timeline. If it's a non-party, there's not a 30-day rule. It's just reasonable notice and reasonable time period. So consider that when you're deciding if you want to request that they bring documents to the deposition. There is a deposition on written question. So you'll want to consider if you want to use that. These are good when you're only seeking business records affidavit type questions, and there's companies that do this. You just provide the questions and send them to the company. So in a deposition on written question, you don't actually attend the deposition, just the court reporter does, and they submit to them written questions, and the normal ones would be the business record prove up. Are these documents that you keep in the ordinary course of business, so on and so forth. And then you might, in certain circumstances, have additional questions. So, for example, I sent it one time to a company where the opposing party owned stock in that company, but it was a closely held company. It wasn't a public company. It was closely held, and I wanted to know, is the stock transferable to my client under their stock plan? Has there been a recent sale of the stock? How are they valuing the stock? And I needed to know exactly how much stock my client's husband had. So that was something that was just limited questions. I didn't need to take a full deposition, but I sent a court reporter with a deposition on written question. So that's nice because it's not as expensive as taking a full deposition. You might also do that in other circumstances that are similar, where you're just trying to get some information, a little bit of narrow information. So consider that as an option. It gives you the option here to consider that. So your questions. Obviously, you need to draft questions for your deposition, unless you're going to wing it. But I wouldn't recommend that. I would write out the questions and be thoughtful about it. And we have included here under the I things you should think about. So what do you need to prove? Look at your pleading. What are the elements of proof? What are they going to say bad about your client? So what's the bad facts that you need to know ahead? You can use the deposition to nail down their story before their lawyer has kind of given them a different spin on their story. So earlier in the case would be helpful to that. What admissions are they willing to make? Sometimes you're preparing for a case and maybe half of it they're agreeing to. You don't even need to prove certain facts. So if you can get them to admit certain things, that'll narrow your preparation for your hearing or your trial. Find out what the support is for their story. So do they have other people who witnessed whatever their story is and what they're telling you? You also can have a list of questions you just always ask in a family law case that maybe you don't have a real suspicion of, but humans being humans, you might hit a gold mine. So have you ever been arrested? Have you ever hired a prostitute? Have you ever taken drugs? Have you ever been on a dating website while you're married? Things of that nature. So we have those helpful hints here in your template, and you can add ones that you prefer and have that for your staff or other lawyers in your office. Objections. So, of course, there's limited objections in a deposition. We don't get to have our full range of objections. Many of them are held to trial, but you do get to object non-responsive, and we do have a section on defending the depos that talks more about that. And you want to be aware of what they're objecting to. So if you're taking the deposition, really all you're objecting to is non-responsive. If they're defending the deposition, they would be objecting form mainly. And they should not be giving explanations of their form objection without your inquiring about that. So they shouldn't be kind of coaching their client through their objection. So you want to be aware of that, what the rules are on that, and we have a little reminder of that here. This reminds you and allows you to assign somebody to hire the court reporter. If you're going to have a videographer, to hire the videographer. To reserve the room where the deposition is going to take place, whether that's in your office or a neutral place or the other side's office. This is a checklist where you can assign somebody to have the subpoena and notice served. And then you need to send notice